Hello, and welcome to Group 13's discussion on equality. The Constitution of the United States has several provisions in place to help ensure equality for its citizens. The 13th Amendment was ratified in 1865 and states in Section 1 that neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. The 14th Amendment, Section 1, proclaims that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of the law, nor deny to any person within its jurisdiction the equal protections of the laws, and was ratified in 1868. The last of what were called the Civil War Amendments, Section 1 of the 15th Amendment declares the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. Although adopted to the U.S. Constitution in 1870, the 15th Amendment was not enforced until the Voting Rights Act of 1965. The 19th Amendment was ratified August 18, 1920, after nearly 100 years of protesting, and finally allowed women to vote. Perhaps today's most recognizable amendment isn't an amendment at all. The Equal Rights Amendment was first proposed in 1923, then revived in the 1960s, and finally approved by Senate in 1972, but failed to ever achieve ratification with the required 3/4 of the states. Without ratification of the Equal Rights Amendment, sexual equality is still not protected by the United States Constitution.
Hi everyone, I'm Aaron, and I will be going over relevant Supreme Court cases in regards to our topic of equality and other groups, which consist of gender, gay, and lesbian rights. So we first have the Civil Rights Act of 1964, and the Civil Rights Act of 1964 is a landmark civil rights and labor law in the United States that outlaws discrimination based on race, color, religion, sex, national origin, and later sexual orientation. It was signed by President Lyndon Johnson, and it outlawed segregation in businesses such as theaters, restaurants, and hotels. The Civil Rights Act of 1964 also banned discriminatory practices in employment and ended segregation in public places such as swimming pools, libraries, and schools. Next, we have the Supreme Court case of Lawrence v. Texas. Lawrence v. Texas was a landmark decision of the U.S. Supreme Court in which the court ruled that U.S. laws prohibiting private homosexual activity between consenting adults are unconstitutional. There's a little backstory behind the Supreme Court case. So in 1998, John Lawrence Jr. was arrested along with an acquaintance at his apartment in Harris County, Texas, when sheriff's deputies found them engaging in sexual intercourse. Lawrence and his partner were charged with a misdemeanor under Texas's anti-sodomy law. The Supreme Court later struck down the sodomy law in Texas in a 6-3 decision and invalidated sodomy laws in 13 other states, making same-sex sexual activity legal in every U.S. state and territory. Next, we have Obergefell v. Hodges. Obergefell v. Hodges is a landmark civil rights case in which the Supreme Court of the United States ruled that the fundamental right to marry is guaranteed to same-sex couples by both the Due Process Clause and the Equal Protection Clause of the 14th Amendment of the United States Constitution. The 5-4 ruling requires that all 50 states, the District of Columbia, and insular areas to perform and recognize the marriages of same-sex couples on the same terms and conditions of opposite-sex couples, with the accompanying rights and responsibilities. And lastly, we have a pretty important Supreme Court case, which is Roe v. Wade. So in 1970, Jane Roe filed a lawsuit against Henry Wade, the district attorney of Dallas County, Texas, where she resided, challenging a Texas law making abortion illegal except by doctor's orders to save a woman's life. In her lawsuit, Roe alleged that the state laws were unconstitutionally vague and abridged her right of personal privacy. In 1973, the Supreme Court of the United States made a landmark decision in which the court held that the Constitution of the United States protects a woman's liberty to choose to have an abortion without excessive government restriction. This Supreme Court case has come under a lot of scrutiny from anti-abortion movements across the United States back then and presently, and has been threatened to be revoked on multiple occasions by many different politicians who are opposed to this Supreme Court decision.
Class, my name is Yosemite. I'm going to talk about some legislation and executive orders. For my first slide, I'm going to talk about how California bans insurers from discriminating against people who live with HIV. This passed the Senate 39 and 0 because there is evidence that backs us up. For example, back in the late 90s, the life expectancy was around 39, which caused a lot of insurers to not want to get people who have HIV into their plan. But right now, the life expectancy is 70 to 78, which concludes that this disease is no longer fatal, and it should allow people who have this to get life insurance now, since they will be treated equally as any other client. This made it a lot easier for many people who wanted to get life insurance back then. For my second slide about equality is that same-sex became legal to marry in all 50 states in 2015, but one of the most important ones was in 2008 when a gay couple sued the state officials because they are violating the 14th Amendment of right to equal protections against the law. Ever since transgender started, it was difficult for them to fit in because everyone didn't agree to the choice. But recently, the government pressured schools to allow transgender boys to use the boys' restroom, and also allows them to join sports because they were not allowed to be discriminated. I say pressure because many people, even the schools, did not want to. And also, now in mostly every document, it asks if you are a male, female, or rather not say. In 1969, there was an executive order number 1147, which means that it prohibited discrimination of race, color, religion, sex, handicap, and age, etc. But it was made so that everyone had the same rate of getting hired to a job and not be biased because of the gender. One of the reasons that impacted this was because during the World War II, many women took jobs that were made for men and showed they were just as capable as they were. But I also feel Martin Luther King impacted this also for the race and color part. In 2014, they recently added onto this legislation to add sexual orientation and gender identity. This was due to everything going on and because they were tired of being treated differently while getting a job, but this was mostly to protect gays from decreasing their chances from everyone else because they preferred because of their preferences, and now they could also identify as the gender they like, which was also created so they could feel more safe when they are having an interview or filling up their papers for that job.